Welcome. We are honored to have you listen and participate in these dialogues produced by the Cora de Brotza Foundation. To learn more about the Foundation and about how you can help us in our mission of unearthing untold stories of moral energy, visit virtuesofpeace.com. There, you can access our show archives, show resources, visit our Etsy shop, and support us with a donation. virtuesofpeace.com. Hello and welcome to Virtues of Peace. My name is Hope Elizabeth May, and I'm joined by Michael Buzzy and Randy Olson, and we are here doing a second installment on Evelyn Grubb's petition to the United Nations. Last week we began discussing this. It was the 50th anniversary. June 7th was the 50th anniversary of when Evelyn Grubb submits this petition to the United Nations. As we said on that show, we actually discussed this for the very first time back in 2020, December 10th, Human Rights Day. So this is actually our third installment or our third pass at this topic of the UN petition, authored by Evelyn Grubb and a team of lawyers. So last week, we pointed out that there are really two instruments of international law, public international law, that are used in this petition. One is the Universal Declaration of Human Rights, and the other is the Geneva Convention, number 3. And we spent some time last week talking about the differences between the Universal Declaration of Human Rights and the Geneva Conventions. There are 4 of them. And we're continuing that discussion today. We hope to focus mostly on the Geneva Convention piece of the argument, but there were some loose ends regarding our discussion about the Universal Declaration of Human Rights that we would like to close up in this conversation. So I'm just going to read again this passage that we spent a lot of time talking about last week. This is connected to the UDHR, the Universal Declaration of Human Rights argument. And in this argument, Evelyn Grubb makes the point that, and here's the quote, there is a particular relationship, a natural dependency by all the family on the head of the family, by the wife on her husband, by the children on their father, which reinforces the right to know the truth with certainty when the status in question is that of the head of the family, the husband and father, on whom the others depend by nature and civilized custom. We spent a long time, that's at the end of quote, and we spent a long time talking about this and focusing specifically on the claim that the natural dependency on this head of household reinforces this right to know with truth. And so just to zoom out for a second, the broad argument here is that the Universal Declaration of Human Rights explicitly mentions the importance of the family and that it is a unit deserving of protection. And what Evelyn Grubb does here when she's appealing to the Universal Declaration of Human Rights is focus on that language about the family being worthy of protection, and then expand or distill that and how that connects to the right to know the truth, especially about the head of the household. And one of the loose ends that we we need to tie up here concerns the social context. So this is 1971 when Evelyn Grubb lodges this petition. And we said last week that the social context is really important to understand this head of household argument. And so the social context was not only discriminatory against wives, women, and in particular, wives. But also, it just didn't even, the state laws did not even acknowledge or recognize in the wording of their laws the missing. And so we're going to go into that deeply. I just want to open it up to see if I have left anything out, if anybody wants to add anything to that summary. I should say that Randy last week took issue with this argument that Evelyn Grubb makes, that the head of household status should not make a difference in terms of the level of protection or duty regarding the right to know the truth. That is, even if someone is not a head of household, the right to know the truth by the family members about that person is just as great as if the missing person was the head of the household. So the claim was that really should make no difference. And then we added that the social context needs to be taken into account to understand this claim, and we're gonna talk about that context in more detail. I just want to see if either Michael or Randy want to add anything to that summary.
Well, I don't want to add anything to the summary, but I do want to ask one question, which for me is underneath this conversation about like the origin or the history of this idea of the right to know.
Mm,
Because I was looking at these two documents, the Geneva Conventions and the Universal Declaration of Human Rights, and nowhere in there is it clearly articulated that the family has a right to know anything. It
mhm,
talks about the right to correspondence, and it talks about the right um, to have protection for the family. And so I'm assuming this is referring to like in Article 16, number 3 of the UDHR talks about the family being entitled to protection. I'm
mhm,
just trying to isolate where the right to know would live in these documents.
mhm. Yeah, so you're right. The language is not explicitly stated, and so there's also a very specific philosophy of interpretation going on here. Um, but I think I'll just start with Article 16 because we could talk about other articles in the UDHR. Um, but Article 16, the argument that Evelyn Grubb makes is that if you're going to protect the family, right, then that implies the right to know what is happening with the head of household. Because without that information, and this is why, like, in order to really understand this, you really need to flesh out the legal context, the background here. And the petition doesn't do an excellent job of that because it's a petition to the United Nations. And really, the details, as we said last week, really concern state law if you really want to get down into the granular understanding of it. But yeah, I think the argument is, okay, if you're going to protect the family, then the family needs this information, especially if it's the head of household, because the family can't do anything without this information. And why can't it do anything? So this goes into the very specific problems encountered by the wives of the POW MIA. And I did add to the show resources. It's very, very useful. I found on the congressional record from October 28th, 1971. It's about a 4 or 5 page summary of the young lawyers section of the Florida Bar Association who decided to work with the wives of POW MIA. And again, like the show resources page has this, check it out at virtuesofpeace.com. But it all depends on whether or not, number one, is there a power of attorney? And thankfully, Evelyn Grubb did have broad power of attorney that Nuke Grubb left for her. So there are all different kinds of powers of attorney. Some of them are narrow, some of them are broad, some of them have expiration dates, some of them don't. Some of these wives had no power of attorney. What does that mean? That means that they were not authorized by their husbands to act on behalf of their husband's interest, for example, property interest, etc. So they couldn't do anything. They couldn't sell anything if it was in his name. So there's that piece. There's also the fact that at this time, a married woman had to like a married woman's identity basically merged with that of her husband's. Her bank account merged with his. Uh, she needed his signature on various things, and so it became difficult for women, even if they did have a power of attorney, to do things like buy a car. I'm going to read actually a, a a page from You Are Not Forgotten. Again, this is the book by Evelyn Grubb and Carol Joes. And this is on page 59. And in this section, Evelyn talks about the difficulties buying a car. And again, she did have power of attorney, but what happened was businesses wouldn't respect the power of attorney. Even if women had this legal document, it was not necessarily respected. So here's the quote. In May 1966, Nuke had been captive 4 months, and I was 7 months along in my pregnancy. I knew we'd soon need a bigger and more reliable car to transport the new baby and 3 growing boys. After test driving numerous brands, I decided to buy a Volkswagen station wagon. It seemed to be the best value for the money. It was roomy, with enough space for me, the 4 kids, and Heidi the dog. When he got home, it would handle Nuke too, and all our fishing and travel gear. It would also offer safe driving and riding comfort. I knew Nuke would love it. We had lived in Germany and we knew they made good, reliable vehicles. I'll take this one, I told the salesman after test driving it one more time. Where is your husband to approve the purchase? I was annoyed about that, but said firmly, quote, my husband is overseas and unavailable. I have the legal right to purchase this car. I'd like to buy it now. How do I know that? You'll have to trust that I have the necessary papers, which I can produce for you when we agree on a price and you write the sale up. If you can't or won't sell it to me, I'll go elsewhere. But please know, I'll continue to do that until I find someone who understands that I'm an adult woman, ready and able to make decisions like this one. I do believe I'll find someone somewhere who will sell me this model Volkswagen station wagon. Looking skeptical, he went away to consult his superiors. I duly produced my power of attorney for them. They sold me the car. I drove away in it. It was a small victory of sorts, winning one skirmish in what had become a long, dreary war of my own. Thanks to the power of attorney, I'd won this round. The discouraging part was how many rounds I had already gone in just a few months, and how many more I might have to face before Nuke was freed and came home. And so that's Evelyn Grubb describing the difficulty in buying a car. And so again, Randy, like this question of where's the like right to know the truth spelled out? And I think when you understand this, you need this information, because once the status is certain, like a whole different suite of rights kick in, right? There's a determined status, certain legal duties and rights are triggered, etc. So I think the argument is there, that, and it's not spelled out in the petition clearly, as I said, but the right to know the truth is implied by the duty to protect the family. And again, the family can't function without this information because of the specific legal context in which the wives found themselves. And the other thing I want to say is women, and another, it's actually on the show resources page. It's an article from Time Magazine, 1971, and it says that Evelyn Grubb tried several times to get a credit card and she couldn't get it because at the time wives needed their husband's signature to get a credit card. In 1974, this changed because there was a Supreme Court case called Reed versus Reed, that made gender discrimination unconstitutional. And Ruth Bader Ginsburg, who we mentioned last week, wrote the plaintiff's argument for that case. That's 1974. So this is 1971 before that. And so I don't know if I'm answering your question, Randy, but yeah, it's implied. If you can't protect the family if the family can't transact business like normal business, day-to-day business, selling things, buying things, etc.
No, I mean, that does answer the question. The reason why I was bringing it up, is like upon surface level investigation of the right to know or the right to truth,
Mhm,
the first thing that pops up is about like exposure to chemicals. And it's
mhm,
like you have these rights to know about your environment.
mm,
And but there was nothing about prisoners of war, and it took a while to like understand
mm,
where this was actually coming from, and
mhm,
it's in context of protecting families
mhm,
based on the circumstances of the local governments.
mhm.
And so like the international document, it just like has this broad requirement associated with correspondence and then duties on the detaining country to notify the local country, and then it's like it's up to them to sort it out. And I guess what the case I'm hearing is you you're making an argument that the local, like the United States, did not have things lined up properly,
Well, you're
so
talking about
that,
talking about the Geneva Conventions,
well, I'm trying
many
to talk
powers and
about
so forth.
both. Yeah.
But I'm trying to just focus on the UDHR.
Oh, okay.
And because your question was about Article 16, right? Was it like Article 16 just talks about the the natural, it's subsection 3, Article 16. The family is the natural and fundamental group unit of society and is entitled to protection by society and the state. And so, yeah, I understood your question to be like, where do you get the right to know the truth from that language? And the answer is you have to understand that the family is going to be jeopardized given the specific legal context in some countries, in the United States, in our example, if the head of household's status is unknown, right? There's also Article 12 and Article 20 that may be relevant to the right to know. Article 12 says, no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence. And one could make an argument that this is a kind of, insofar as this information is not being disclosed, this is an arbitrary interference with family. And Article 20 says everyone has the right to freedom of peaceful assembly and association. And I tried to go here last time, like intimate association, as I said last week, is worthy of constitutional protection in this country, the right to intimate association. And one could argue that, without this information, there's an interference with my right to associate with other people, and especially people who are close to me.
So I understand what you've said, and with a broad stroke, then after 1974, would this petition to the international organizations no longer have as significant of a case because the head of household situation gets changed fundamentally with the equal or the gender discrimination situation being, at least in theory, improved?
Yeah, I mean, I think it would still, the argument would still have great relevance. I mean, it's 1974 that you have this decision, and as we know from the history of Juneteenth, it takes it takes years, decades for something to be implemented. And Randy, you and I were talking before we started recording. You just like casually took a look at the Geneva Conventions, and we were pointing out that like people don't know what they say. And this is a repeated complaint by Evelyn Grubb that Like nobody, this is page 58. Had anyone in our government actually read the Geneva Conventions? Did anyone in the Air Force read them? So even if we have these Supreme Court decisions, it doesn't mean that people know what they are. Um, and so the argument is always valid, I will say. Uh, and it's still valid today. We still have people who have the head of household mentality. We still have, governments that have laws on the books that no one has bothered to change or challenge. So yeah, I think it still remains valid. Absolutely.
Fair enough.
Michael, anything?
Yeah, the discussion, especially since we had discussed there was never any specific language that states that a member of a family, if the head of household goes missing, that you have the right to know their location. It struck me as very similar to the legal construction of the right to privacy in the United States. There's never anything that's explicitly stated in the Constitution that an individual has the right to privacy, but from various components of the 14th Amendment, Due Process Clause, First Amendment, that it has sort of been inculcated over time and constructed throughout these various decisions through the Supreme Court. And then eventually there's this like not explicitly put down in the Constitution right to privacy, but a generally understood right to privacy based on these various decisions. And so kind of drawing from either like Article 16 of the UDHR and some components of Article 20 as well, you can also patchwork it together and then see how the argument that Evelyn Grubb presents is valid based on all these different components.
Indeed. And as you know, Michael, I mean, although the Supreme Court did find a right to privacy, and it's the Griswold versus Connecticut case where they do that, there are some dissenting judges, and still to this day, as we said, this argument presupposes a certain philosophy of statutory interpretation, and that is that not every right that exists is explicitly mentioned. And we can infer rights from other rights that are mentioned. So not everybody agrees with that. We're not going to get into a debate about that, but indeed, there's a specific philosophy going on here. I also want to say that although the right to know the truth, the right to know by the family is not explicitly mentioned in the Universal Declaration of Human Rights, it is explicitly mentioned in the 1977 protocol to the Geneva Conventions. And I think it's the show resources from last week. You can click on and you could see that the duties that follow in that 1977 protocol, the language, it's called the general principle. What prompts all of those duties, and this is explicitly stated, they're not inferring this from anything, is the right of the families to know. So that's 1977 protocol to the Geneva Conventions. And so there you see that norm explicitly mentioned. And I think it has been percolating all along. And why Evelyn Grubb's petition is so important is because it anticipates that norm, that 1977 norm. And that is that we talked about this on the very first discussion of the show back in December 2020, the right to truth. So there's like the right to truth. That's the way that it's discussed now. And there's like the right to know. The buzzword you want to work with if you're going to track the developments in international law now is the right to truth. So very good. So basically, to sum up our discussion about the Universal Declaration of Human Rights piece of this petition is that to really understand it, to really understand Evelyn Grubb's argument here about the head of household, you really that's an invitation to look more deeply into the state law, family law, probate law, estate law, etc. Because once you do a deep dive into those particulars, you see that the law is narrow and also discriminatory. It's narrow because it doesn't even acknowledge that someone could be missing in action. And so what these lawyers did in Florida, and this was the young lawyer section again of the Florida American Bar Association, the Florida Bar Association, is they actually amended the state statute to include specific language about prisoners of war missing in action, and that um, this concerns technical issues about what's called conservatorship. And anyway, I don't want to go there, but the lawyers in Florida, work with the state legislature to amend the statutes to include definitions that included the status of POW MIA. It's pretty cool because the law just didn't acknowledge them, and that was presenting problems. And you add on to that the discriminatory laws that required husband signatures, etc. These wives were encountering problems that prevented them from operating the household. So check out Reed versus Reed, 1974, and the Equal Credit Opportunity Act, also 1974, and these things began to change the policies of banks and so forth. And what's fortunate for Evelyn Grubb is that she did have broad power of attorney, but as we understood with the passage I just read, she still encountered problems. And if you look at that like short piece from the congressional record, the lawyers there say, yeah, they can attest that women who had power of attorney, they like businesses they weren't respecting it. In some cases, the power of attorney had expired. And I highly recommend, if you're interested in the legal technicalities, to look at that on the show resources page. So moving on to the Geneva Convention piece of the argument, as we said last week, it's really the third Geneva Convention that is used in the UN petition. And we said last week also that when we say Geneva Conventions, there are 4 of them, 1, 2, 3, 4. The first one concerns the wounded on land, and that was adopted in 1864 by many countries, not the United States, by the way. The United States signed on maybe almost 2 decades after that. Geneva Convention number 2 concerned the wounded at sea. So you have land, number 1, sea, number 2. The third concerns prisoners of war. And the fourth, as we said last week, brand spanking new in 1949, put the protection of civilians. And so, as we said last week, the Geneva Conventions were upgraded following the horrors of World War II. We're really working with legal instruments from 1864 and the Hague Conventions, and they needed to be updated, and we did that in 1949. And so the third Geneva Convention is, again, concerning prisoners of war. And really what Evelyn Grubb's petition focuses on is this language in Article 120 about the detaining state. So this would be North Vietnam. The detaining state's duty to communicate the circumstances of death to the other power. And so I'm just going to read some language. And this is from the petition, Evelyn Grubb's petition. Quote, what is in point here is that the Geneva Convention, which was primarily designed to protect the rights and ensure humane treatment of prisoners, also extends its protection to the rights of persons other than prisoners. Okay, that's quote number 1. Quote number 2. It is obvious that these provisions, that is Article 120, by placing a requirement on the detaining power to fully report the circumstances of death, indirectly limit the power to do away with the prisoner. To what extent the provisions are certainly beneficial to the prisoner, but the primary beneficiary of the required report is the family of the prisoner. And the last quote, the primary reason for the exactness of the report of death is for the benefit of surviving family members who have a right to know with certainty that death has occurred and the circumstances which brought it about. So this is a really interesting argument. And the argument here is that again, you can sort of infer from this language in the Third Geneva Convention, Article 120, that these things exist. These duties of the state to report the death, circumstances of the death, are really for the benefit of the family. I think that's so interesting because it's pointing out that, okay, the Third Geneva Convention is sort of like tacitly or indirectly acknowledging that the family exists. That's huge. We've talked about on the show a number of times. Bertha von Suttner's, her claim to fame is that she brought to consciousness the effect of war on families and on women in particular. And so here's the argument that you have the Third Geneva Convention sort of like acknowledging and recognizing that there's just like this other party that is entitled to this information. So that's just section 120, and that's just the Third Geneva Convention. I'm going to stop there and see if anybody has anything else to add.
Well, I'll point out that actually pulling up the Geneva Conventions was something very surprising to me, very eye-opening, because I'd always studied them tangentially with something else, and actually pulling the document up was very eye-opening for me. And this set of things that are in the Third Geneva Convention, they're striking to me, I guess, for a number of reasons. The one thing that's useful, I guess, to acknowledge is there's all these provisions associated with correspondence, like the prisoners have rights to send letters. And there's all these agencies that are built into the Third Geneva Convention that create the like chain of communication between a prisoner and the family in some, like, it's pretty direct language, frankly, for one document. Now, it's always a conversation of like, well, what's written versus what happens, which is obviously a long and impossible conversation with anything like this. But I do see how it's implied that, like, okay, if the detaining country must have a report of every person who they have prisoner, and they have to have a report and send that report to the central agency and the country of origin for the prisoner of like what happens to that prisoner, then it's implied that, yeah, like there are people who might benefit from that information. Although, just to continue being difficult, I wouldn't say that it's solely for the benefit of the family. I can see some obvious ways where other powers in the government would benefit from that information.
Yeah, I think that's fair. So, but the family is definitely included in the set of all entities that would benefit from this information.
Yeah. So, I mean, certainly in context of like the benefit of the home nation, because the family being like bedrock of that nation, it's like it's in the nation's best interest to get information to the families if they're doing things well on their own turf, so to speak.
Yeah, and when we first started talking about this petition on December 10th, 2020, I pulled out specific language from the petition that I did not mention in this round, and that is this distinction between like this burden of concern. I forget the other burden, but the language goes on to say that this actually benefits the prisoner because the prisoner is going to, that there's like, yeah, that's the burden of concern versus the burden of captivity. The prisoner is suffering the burden of captivity insofar as he is, his liberty is restrained and he's a prisoner. But there's also this psychological burden, what they call the burden of concern. This is in Evelyn Grubb's petition, of like, oh, my family doesn't know about me. My family doesn't know. And so this provision of the Geneva Convention is to alleviate this burden of concern from the prisoner. So he's not suffering mental anguish and the burden of captivity, that this lightens, so to speak, his load and what he has to carry if he knows that this provision is there and protecting his the right to know by his family, if that makes sense. So it's also the prisoner that's being benefited. That's in the Evelyn Grubb's position. I think that's a really fascinating argument as well. Yeah.
Yeah, I mean, I agree. I think it's fascinating, and you know, I have to read it because I'm interested to understand. Because at least conceptually, it could be troubling information, right? Like I think an argument could be made the other way, but I'd have to see it
Oh,
fleshed
it's
out
the
all the way.
truth. I mean, we need the truth regardless of how painful it is. So yeah, it could be information that is painful to process, but we need the truth here. And so, yeah. Michael?
Yeah, I actually had like sitting here percolating with all these thoughts of what we've been talking about, and I guess to just throw in some more facts of the Grubb story and how it all ended up playing out in the years that had followed Newt Grubb being shot down in 1966. We later came to find that North Vietnam had purposely portrayed a false narrative that, for one, Newt Grubb was alive, and that two, the prisoners were being treated humanely. And so within the context of Article 120 in the Geneva Conventions, I was curious, how does, like, when a nation purposely bars the truth from reaching those families, and in fact even goes beyond that to, instead of just denying the circumstances, to portray the exact opposite of what Newt Grubb and the other prisoners were experiencing, that their treatment was humane, that he was still alive when he in fact had been dead for quite some time at the point in which Evelyn's giving her petition to the United Nations in 1971, that maybe that was also something Evelyn was contemplating as well, that under these statutes and in the international law realm, there should be, mechanisms by which to rectify situations such as that, when a nation such as the detaining nation, such as North Vietnam, is purposely portraying this false narrative. So I was wondering if we could touch on that. I'd be curious to hear like how all of this fits into, I guess, when an actor, that nation, acts in a way that is completely opposite to what these articles would stipulate that they do.
Yeah, there's definitely, I don't have it handy, but I do recall that a major piece of this petition, and let me see, is to, okay, here I have it, quote, ensure respect for the convention. And so, yeah, Evelyn Grubb, as well as the lawyers who worked with her, had this position that, yeah, this disinformation campaign by North Vietnam is just so, yeah, not respecting the whole philosophy behind the convention, and that itself is a violation. So I'm just actually again, thanks to Kevin Settle and Van Grubb for like digging these documents out of the attic. And this is a letter from John Norton Moore, who is one of the lawyers that worked with Evelyn Grubb. This is dated January 15th, 1971. Quote, I believe that the effort to develop an international legal approach and to call attention to the duty of signatory states of the Geneva Convention, not only to respect, but also to ensure respect for the convention, is a sound approach. So yeah, this is so obviously, the misinformation campaign is so obviously violating the very purpose of those provisions of the convention. Does that address your concern, Michael?
Yes, thank you.
Another thing I want to mention is sort of like throw a, and this, we keep doing this dive because there's so much to unearth and unpack, not only in this UN petition, but also the whole story about the Grubb family, the National League of Families, et cetera. There's so much here to unearth and unpack. And my continued research of this, I learned that, so here's this International Law 101. So when a state signs and ratifies a treaty, they can declare what's called a reservation, which is basically like, we're going to agree with, like, let's say the treaty has 20 articles. We agree with like all 20 articles, except we're going to like take issue with Article 19, and we're going to say that we're not going to really obey that in these circumstances. So it's a kind of, a reservation or like an exception, if you will. And states do this all the time. United States among them. And the Soviet bloc countries and the communist countries at the diplomatic conference where these Geneva Conventions were being updated in 1949, declared a reservation to the Third Geneva Convention. Actually, they declared a number of reservations, and you can, if you really, want to do a deep dive, you can read these reservations on the website of the International Committee of the Red Cross. All of them are there, but North Vietnam takes issue with Article 85, which concerns the treatment of prisoners of war. And they basically say, we're not going to, respect this article if the prisoners of war have been convicted of war crimes and crimes against humanity. And all of these prisoners of war are war criminals. Therefore, they're not prisoners of war. Therefore, they're not entitled to the protection of the Third Geneva Convention. Why are they war criminals? Because they're targeting civilians in their aircraft. So, like, the North Vietnam actually has the position that these people are not prisoners of war. And we declared, right? We actually, when we signed the Geneva Conventions, we said, like, if these people are war criminals, they're not getting protected by the Third Geneva Convention. And these are not prisoners of war. They're war criminals. And therefore, we can do anything we want, okay, including misinformation campaigns. Okay, so that's a conversation for another day, but that's going on in the background here. Does North Vietnam even think that these are prisoners of war? And I think insofar, and I think, Michael, like this whole thing about why are they engaged in this propaganda campaign about, they're treating these prisoners humanely? Doesn't it seem like they're sort of like acknowledge that they are prisoners of war and they are treating them humanely, right? So they are kind of recognizing that they're prisoners of war and worthy of protection, or if they're just, being jerks and they're doing anything they want. I don't know. This requires more study. I'll just pause and see if anybody has anything to add. Go ahead, Michael.
That's a very fascinating to like even have that knowledge in the background, where it would almost seem as if North Vietnam, in their signing of the Third Geneva Conventions, if they were to, if it were to come out that they were treating these prisoners inhumanely, or the news of Nuke Grubb's death had come out sooner, that they could just simply point, like you had said, and say, no, these are war criminals, they bomb civilians, therefore they are not entitled under the protection. We can point to us signing the Third Geneva Conventions and stipulating that this would be an article we would not follow, and then going that along the line of rationale, that would almost imply and play more into, I guess, legitimacy for it, if that was something that they were aiming for. But then obviously on a global scale, I guess like very nitty gritty legally, they could point and say, see, we're following everything we said we would. No one's a prisoner of war in North Vietnam. They're all war criminals. So there's no need to protect any of these individuals. But then, to then go purposely do the exact opposite of what they were doing and go out and produce this misinformation campaign and portray to the world that all these prisoners are fine, to invite, did Cora Weiss or an individual, I could be remembering wrong, but individuals had gone over and maybe had seen these facilities, met with prisoners, so they could say, hey, look, see, we are doing this correctly, sort of like a show masquerade sort of event to show that these prisoners of war are being treated humanely. So that's a very interesting distinction as well, that why if you could just stick and fall back on these legal doctrines that you've already said you would follow in international law, that would give you legitimacy. But then, yeah, to go about a misinformation campaign to do the opposite of that, which then I think would even, that facet of them doing that probably even plays more into Evelyn Grubb's argument in the petition that there is a right to know, and that even she could probably even point to North Vietnam and say they are completely in violation of what they said they would do, that if they were just to be treated as prisoners of war, that information could still flow. But by still impeding the flow of information and spreading disinformation, that even furthers the grievance being done instead of what would occur if they were to just stick with their original line of reasoning and arguments that they would have under the doctrines that they had signed, along with their hesitancies and objections to certain articles of it. That's so fascinating.
It is, and if you read, I'm pretty sure I don't have the reservation in front of me, the reservation to Article 85. It's like, I'm pretty sure the language explicitly says, captives who have been tried and convicted as war criminals shall not receive the protection of this article. And the other thing is, there was no trial, there was no conviction, there's no process by which the prisoners' actions are being deemed to be war crimes. So that process wasn't in place, and so they're also not complying with their reservation in that case. So it's just a big mess. But anyway, perhaps I'll just throw up to the show resources page, because they're not there now, the page that does have the reservations to Article 85 and other articles as well. They're always fun to read, the state's reservations to various international legal instruments. So anyway, right, there's a lot to unpack and so forth. And before I move on to the Fourth Geneva Convention, I just want to see, Randy, you have anything to add to what? Go ahead.
Yeah, I just wanted to echo basically what you said. I was going to make a similar case for, the importance of, I guess, appreciating the fact that we have due process, first of all, in the United States. Something that's just totally taken for granted in my world, that oh yeah, like a trial in that situation might be kind of helpful, because like I don't get to just automatically assume that I'm not a war criminal when I'm in another country, doing war things. So in any case, the due process point was one you already made. So the next point is, it starts to show the value of international arbitration, right? That's a point we've probably beaten to death over the years, but having another entity which is responsible for doing these kinds of trials it's like you can see how valuable such a thing would be in a case like this, where it's like, well, look, who's responsible for the bombing of civilians? Is it the guy in the airplane? Well, maybe. But then there's these important chain of command conversations where the who's actually responsible, who's the war criminal, and then where do the individual protections actually fall down to, and where do those over intersect with responsibilities? It starts to be a really complex conversation. And you don't get to just like any reasonable person would be able to point to the fact that you don't get to determine the guilt of a person on the spot if you're in wartime. You don't get to do that. Now, it's weird because, yeah, guys in plane dropping bombs, it looks like a criminal if you're on the ground and the bomb is falling at you. But it's when you start to step outside of the, well, who's doing damage and who's getting hurt by it frame, and start to ask well, who's actually responsible, the conversation stops being so cut and dry, and there we have the value of arbitration.
Yeah, it's so complex when you're dealing with a network of actors and the issue of responsibility, and there are degrees of responsibility, right? And there are different theories of responsibility. So, and in Nuke Grubb's case, he was flying a reconnaissance plane. He was not dropping bombs. He was taking pictures. So, it strains the imagination to understand that that particular pilot is a war criminal. Um, so, Michael, any last words before we move on?
Yes, just to echo Randy's point, that whole discussion totally just highlights the importance of international arbitration. The two warring parties, if you're in the plane dropping the bombs and you're on the ground having the impact of the bombs, both of those parties are going to have quite polarized, biased opinions of their actions. And so that's just speaks to the importance of all the international framework that we have discussed throughout the whole of Virtues of Peace, and that now it's up to both of the duties of those states and those actors to go before the international body and to plead their sides and see what the result will be.
Or you have, a commission that's sent in to do fact finding. This is what the international community tends to do, that you don't have the belligerents putting forward. Those are not the only sources of the facts, that you have like an independent panel of experts go in and do what's called fact finding. And the fact finding is, one piece, but then you have to apply theory to the facts. You have to have a theory of responsibility. So there's something in international criminal law called joint criminal enterprise. And there's all these different degrees of responsibility depending on how much how close you are to the control of the thing, and there's command responsibility. So fact finding is one really difficult thing, but then, you have to apply the theory to it, and it's very complex. And international arbitration, and I would also say even criminal adjudication. So what is done at the International Criminal Court, which is not arbitration, but prosecution with facts, with arguments, the prosecution, defense, and the victims' advocates. Extremely complex. Just FYI, he said, people don't read the Geneva Conventions, okay? It's a thing that Evelyn Grubb makes apparent in her book. And this book is written before the International Criminal Court comes into existence, which is really like 2002 that the International Criminal comes into existence. Last night on Jeopardy, there was a question about the International Criminal Court, and nobody knew the answer. And it was like something so basic, like, what is the ICC? So the person who buzzed in went, international. I'm not making it up. You can check it out. And so, there's so much ignorance about the Geneva Conventions and now about international criminal law. And we do well to keep educating ourselves on these things. So, as we've been talking about, the third Geneva Convention concerns prisoners of war and the duties that the detaining state has towards them, right? But I also want to draw attention to the fourth Geneva Convention, which, as I said, was brand spanking new in 1949. Not until August 12th, 1949, was there an explicit international legal mechanism protecting civilians during armed conflict. The Fourth Geneva Convention does that. And I want to draw attention to a couple of articles that I think also relate to the argument in Evelyn Grubb's petition. And again, this is the Fourth Geneva Convention concerning civilians. Article 25, which concerns the right to family news, and Article 26, which concerns connecting families who have been dispersed from armed conflict. Again, to remind you, the Geneva Conventions apply during armed conflict, right? So there's sort of a narrow set of regulations that apply when we are engaged in armed conflict, both international and local. The Common Article 3 concerns applying the Geneva Conventions to civil wars. So there could also be a question, and that is a question in Vietnam, like, what is this? Is this like an international conflict? Is it a civil war? And the United States position was it's an international conflict, and I'm pretty sure North Vietnam said, no, it's like a civil war, and these articles don't apply. Again, conversation for another day. But the Universal Declaration of Human Rights, as we've said, applies at all time. But during armed conflict, the Fourth Geneva Convention lays out the rights of civilians and particular families. And I just thought this would be an interesting thing to look at concerning Evelyn Grubb's petition, because Article 25, basically, I'm going to read, this is a sort of summary. It's the right of any person living in a country at war to give and receive family news. This lays an obligation on the belligerents not to put any obstacles in the way of such correspondence. Parties to the conflict must forward such correspondence speedily and without undue delay. And so this is this right to family news that is inheres in civilians, and that countries cannot impede this correspondence. And if a family has been broken up because of conflict, the Geneva Convention commentary on this Article 26 number, Geneva Convention 4, goes on to say, like, this whole reason why we have Article 26, which concerns dispersed families, is because we need to like restore the family unit. That's the language that's used in the commentary. So states must facilitate connection amongst dispersed families. And so I thought that these articles and the Fourth Geneva Convention are relevant because it again sort of like bolsters the very first argument that we talked about in the Universal Declaration of Human Rights. The Article 16, the family is the fundamental unit of society and entitled to protection. And so here you see that being echoed in the Fourth Geneva Convention, that, okay, when the family is like broken up or the communication has broken down, that states have a duty to facilitate that communication and the union. I just thought that was, yeah, really interesting, and would be another way. So like, we can approach the lack of communication and connection between Evelyn and her husband through the lens of his being a prisoner of war. Um, and that raises perhaps the questions about whether he is a prisoner of war. So even if we like grant North Vietnam's argument, he's not a prisoner of war, he's a war criminal, which is a stretch and actually implausible. That's an implausible argument. But even if we were to grant that, there's still this other argument that can be made that it's a family that is broken up and that is not communicating with each other, and North Vietnam has the duty to facilitate the communication and the connection. I have not checked to see if they made reservations to the Fourth Geneva Convention. I shall do so, but I'll just stop there and see if anybody has anything to say. Randy.
I have a question. I'm
Yeah.
wondering if there's been any modification of the definition of correspondence in the world of instant global telecommunication. It's like, are we still operating on the handwritten letters framework, or have we started to talk about like, well, maybe a phone call, or maybe, and now the whole world's using Zoom. It's like, is there like a right to FaceTime? Like, is that a conversation that anyone's having, or
If it is, I confess I'm not aware of that particular piece of information.
Well, I mean, it just seems like it's the logical progression, where if in the 1960s, 1970s, there was an expectation that you were, as a prisoner, allowed to write 1 or 2 letters a month, which is, what is it? That's in the Third Geneva Convention. It's Articles 69 and 70. It's like, okay, so if writing letters is default and like that degree of correspondence is expected, now if we're truly supposed to not get in the way of correspondence, and correspondence is customarily instant no matter where you are on the planet, then it follows, as far as I'm concerned, that like, there's a right to FaceTime. and I don't want to like minimize the issue with the little humor there, but really, this conversation about what is correspondence and how does technology change it seems to be like a relevant discussion.
Yeah, I love it. That's a good question. We can also expand that to like, is there a right to have, a high speed internet at POW camps? Yeah, I haven't done a deep dive into that question. I'm sure that people are looking into such questions. I can't respond to that.
I mean, just to stretch it a little further, I mean, look a little further. 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 I mean,